Hey, everyone. Holy moly, we got a lot of questions coming in here tonight. I'm still typing, trying to get them all programmed in, but welcome back. We've had a little bit of a break. I've had a busy month. It's still not over. I'm going to have a busy few more weeks ahead of me. We're just like lots of clients coming into the firm. I'm in the middle of hiring people. I just had a bunch of trips planned that all just sort of came together, unfortunately, around the same time. So that's been kind of getting me away from the office. So things have just been super busy. I appreciate you guys showing up here tonight. I know it's been a delay. We'll try to get back on a regular schedule, but I will be out of the country again in a few weeks. So there will be another, at least 1 week, possibly two, where I won't be able to make it back in time for the broadcast. So let's dive in here tonight. As you know, I'm David Brannon. I'm the owner of Resolute Employment and Disability Lawyers, also known as Resolute Legal. we focus on representing people who are dealing with long-term disability and employment cases. So tonight is just my regular show where we focus on answering people's questions live on the air. And tonight we've got a lot of questions. So people have sent in their questions ahead of time. I've got probably like 90% of them all queued up and ready to go. I may have to take a little break at some point and log in the last few because I wanted to get the show started here, so I wasn't able to get them all logged in. Okay. Wow. Jen warned me that there were a lot of questions this week, so we're going to dive in here. And let's see. Where do we begin? Let's just dive in. Look at the first question. If you have questions for me, just post them in the chat. Otherwise, I'm just going to go question by question here. Hopefully, I'll hit all the questions that people are looking for. All right, number one. And let's take a look at this one. This one says, I earn $220K. That's a lot. And my LTD any occupation test starts soon. So this person's been on disability for 2 years, and they're about to start into the any occupation phase. Since a new job must pay at least 50%, which would be $110K, how does the insurer decide what jobs I'm qualified for at that pay grade? Okay, this is a very good question. Whenever I get questions like this, I always like to step it back a minute because you have to make sure that we're all on the same page here and that your insurance policy is on the same page. So what I would advise this person, if you're listening, like this is not specific advice about your case, because to advise on your case, I would need to see your policy, because just because the policy says 50%, like first of all, does your policy say 50%? In other words, like once you move to any occupation, the threshold of earnings would be 50%. That's a common thing in policies, not necessarily 50%. Sometimes it doesn't give a percentage, but there's this idea. So what this person is talking about is there's this idea that once you go from own occupation to any occupation, you will still be considered totally disabled if you're incapable of earning up to, and this person's asserting 110,000, which would be 50% of their earnings. So I call that the income threshold, or the gainful income threshold, it's sometimes called. So it is a real thing. It catches people off guard because a lot of people think, well, if you're going to be totally disabled from any occupation, it must include all occupations. So maybe an occupation you could do that could earn 30,000 a year. If you could do that, then you shouldn't get disability benefits. But the way long-term disability works, it's meant to protect your income. So if you have a very high income like this, it wouldn't make a lot of sense for you to buy a policy that wouldn't protect you, wouldn't protect your full income. It would defeat the whole purpose of it. So it is true that a lot of these policies have either these income thresholds that are set out very clearly, like 50%. It'll say that right in the wording. Sometimes it's silent. But what I always tell people is before we go there, we have to make sure that that is actually true. There's a couple of ways that this can go wrong. So one of the ways this can go wrong is sometimes it will say that it's 50% of your salary, but there can be caps. So sometimes the wording is in there, but it will say up to a maximum of X amount a month or something like that. So it doesn't always protect your full income. The other thing is, like, this person says they earn 220. Well, is some of that from bonuses and things? Because a lot of the LTD will not apply to bonuses. Okay. It'll only apply to your base salary. And so there's just a lot of assumptions here, but we're going to go on the assumption that this person has coverage for up to 110K. Okay. But I'm saying that I wouldn't necessarily believe that right now. I would want to be able to look at that policy to make sure. But let's just start from the point of view that we will assume that it does. So how does an insurer decide what jobs you're qualified to do at that pay grade? What they do is they hire an occupational therapist or a vocational rehabilitation specialist, someone who has been trained in how to do these types of assessments. So how it would work is they would do something called a transferable skills assessment or a vocational assessment. They would assess your physical abilities, your education, your work history, like your resume, the types of jobs you've done. And then they would look at what are comparable jobs in the economy that would pay up to 110,000 that you would have the physical and cognitive capability of doing. So they're looking for a match. They would look for jobs in the economy that pay up to 100, that pay 110, where you would match the physical and cognitive demands of those jobs. That's how they would do it. So so in a nutshell, they would hire an expert who would do an assessment, and that they would try to match your see if your physical and mental abilities match any jobs listed in the economy that would pay that much. There are databases, and the name is escaping me off the top of my head. The NOC, National Occupational Classification. That's what it is. So there's different classifications of occupations in Canada, and they do have all the occupations in Canada are classified through this NOC, and they will also have that whole categorization also includes what are the physical and mental demands of the job, the pay range, and all that kind of thing. So that is the kind of assessment they would do. They would produce a report that would show that you are a match or for these three jobs that pay up to pay 110,000, and that's what the insurance would rely on if they were going to deny your claim. Okay, so there you go. Now, I will say that it is not easy for an insurer to find jobs that you would be capable of doing. So if you can't do a job that makes you 220, it's going to be very hard for them to find a job you could do that would earn 110, because it's still a very high income position. And usually the types of things that are disabling you from the $220,000 a year job are going to disable you from a $110,000 a year job. So even though it's any occupation, it's likely that in that situation, if you were disabled from one, you'd be disabled from the other. All right. This might be from the same person, but it's in a related question. This one says, I'm on LTD for depression. Besides seeing my doctors, what specific evidence do I need to prove I can't meet the any occupation definition and handle the stress of 100? Okay, yeah, this is the same person. So depression is a difficult one. Any type of mental illness. I wrote an article a long time ago. It was one of my first articles I ever wrote that actually blew up online. Got a lot of views. But basically what I was saying there is with mental illness, what you have to do is prove that you are doing everything that is possible to do to get better. That's the number one thing you can do. So you want to make sure that you've gone to all the assessments that they asked for. You're on all the medication, that you're doing everything that you're asked for. Then you just have to rely on your doctor saying whether you are capable of returning to a job with stress or not. Now, you can, again, if you can't do a job that is 220, it's unlikely you're going to be able to do a job. If it's depression and things, it's unlikely you'll be able to do a job at 110. No, we don't know your situation, but that would be what I would say, kind of at the outset of that. So what specific evidence? It would be mostly evidence that you are doing all that is asked of you, that you're not denying any medical treatment and that kind of thing. That is how they're going to cut off a person in this situation. They're going to focus on saying that you're not mitigating your damages. So you're not doing treatment. You're not doing all you can do to get better. That's the way they would get you. Apart from that, it can be very subjective, and ultimately you do need a supportive either psychiatrist, doctor, or psychologist who can say that that you would decompensate if you were put back into that environment. Now, you might have to, in this type of situation, you might have to do a trial return to work, or try to do other volunteer work or activities that could simulate to a certain extent what work would be, and then report back to your doctor, see how that goes. And at some level, you may have to do some real world trying to get back, or some type of a return to work, whether it be to a real job or to a volunteer job, to see if you're capable of, basically to see if you're capable of doing it. All right, just a second here. I got to call in the troops here. My dog is really distracting me, but he wants to go out. I'm going to call in the wife here. There we go. All right. And here's another question, I think from the same person. So let's just go through them all here. Does the insurer have to prove that a job paying 50% of my old salary actually exists, is hiring, or do they just have to show I'm theoretically capable of doing it? Yeah. So all they have to prove is that a job that pays 110,000 exists. They have to prove that you have the capability of doing that job. They do not have to prove that it is actually available for you, like locally or anything like that. So they just have to prove that it is somewhat of a theoretical thing but it has to be a real job in the economy. But they don't have to prove that it's available and offered. They often will, because it just takes it one step further. So they often will, like the same people that do these assessments will also provide like job postings of examples of that type of job and that kind of thing. But no, it just has to be a job that's available in the economy that you have a matching skill set to and abilities based on your level of disability. All right. Let's get a little drink here. Get a little breather. Looks like we got a comment. So let's jump back and forth. We'll do these and we'll do some comments. Then we'll go back to these preset questions. So this is Grumpy Kitten. I remember Grumpy Kitten. I know that picture. Welcome back, Grumpy Kitten. Grumpy Kitten is saying, can LTD and CPP restrict moves out of province? Very good question, Grumpy. The answer to that is no, definitely not CPP disability, definitely not LTD either. Where it can kind of come back to bite you is like they can't restrict you from leaving the province, but in a roundabout way, it can result in them terminating your benefits because they will say, oh, like because you moved away, you would have been available to move back to your old employer. Your old employer could have been able to accommodate you because the employer you had a duty to accommodate you. Whereas if you go to try to find new jobs with a new employer, they don't have to accommodate your disability. So they'll basically make an argument that you failed to mitigate by not taking back a job with an employer who had a duty to accommodate your disabilities. Now, if you were able to do the job out of province, like it was a work from home job, then it would completely not matter. But legally, there's nothing preventing you from moving. These disability policies do not insure you for your exact job that you have. They insure you for that type of work. And that's something the insurance usually tries to use against you. So in these types of situations, it kind of works in your favor that you're not insured for that specific job per se. Your insurance, though, is tied to that employer. So there are problems you can get into if they try to force you to go back to that employer and you're not able to because you've moved out of province. It can create practical problems for you. Even if it's a situation where you think that a return to work would be unsuccessful, you're now in a position where you can't even try the return to work very easily because you're out of province. And it can result in you having a hard job proving your claim. Whereas if you were in province, you could go try to do the return to work. It would fail. And now you have the evidence that you tried and that you still have disability and that kind of thing. So just hope that answers your question. All right, let's move to the next set of questions here. This one is about employment questions. So the first set we did were disability. These look like employment questions. This one says I'm on probation. So I don't think that's like criminal probation. I think they're in a probationary period of their employment, whereas that can be 3 to 6 months, can be longer, but generally it's 3 to 6 months. When you start a new job, you can be on a probation period. A probation period means that during that period, an employer can terminate you without paying you severance, is essentially what it means. Great. All right. Now the dog's back at the door, so I drive my wife crazy. Okay, so where was I? I've completely lost it here. So this one says, I'm on probation and need surgery. Does a probationary period give my boss a free pass to fire me for medical absences, or do I still have human rights protections? Yes, you do have human rights protections during a probationary period. So you cannot be discriminated against. It's not like free reign that they can fire you for any reason during a probationary period. If you can prove that the reason for firing you was because of a disability or a perceived disability, then you would have a case. Yes, you would. So yeah, you do have human rights protections even when you're a probationary employee. Now, to be clear, I'm not saying this particular person has like any kind of rights, because again, I don't know all the details. This is not a thing where it's like, oh, it still would need to be proven that that is the reason that why. And there may be other reasons they're firing you during a probationary period, and it's just a coincidence that you are also needing surgery and these other types of things. So you still would have to prove it. And I can't give advice directly to you, but I'm just talking generally how it would work. Now, I think this is the same person, and they had another question. They said, my employer says they aren't sure they can take me back while I'm on medical leave. What steps should I take to protect my job before they actually fire me? So there's not anything you can do to protect your job. What you can do is give the employer notification. So it's important to let them know that you are off on a medical leave, and that you it's important to give them some idea of like when you should be able to return. And if you return, are you going to be able to return to full duties, or would there be something? So the more information you can give the employer, the better for you. Then if they end up firing you, they're firing you right around the time when you're giving them more information and things like that. But there's not really anything else you can do to protect your job. You would just have to play it out. And until they fire you, you technically still have a job. You're on a protected leave. So that is just something that I would say is there's not much you can do other than just give them details of when you plan to return, keep good communication with them, and that's the best you can do. Okay, this is another question, I think, from the same person. So this person's saying, I found out my boss was interviewing my replacement while I was on medical leave. How does this evidence impact a human rights or wrongful dismissal claim? Well, it may help or it may not have any consequence at all, because if you're on a medical leave, they do have to replace you. So it would be normal that they would interview someone to try to replace your job. Like the business does have to go on. They do need to have someone doing your role. So if it's unclear when you're coming back, they definitely would have to hire someone in the meantime to fill your role. So just because they've filled your role with they've hired someone else in the meantime while you're off on sick leave, that does not, even if they're doing your exact job and they advertise it as your exact job, that does not mean you've been fired. What you would need to do is wait until it's time for you to return. If they bring you back and put you in your same role or something very, very similar, then you have not been fired. When it's time for you to come back and they say, look, we're letting you go, or we're not, then that's a case where you've been fired. And the fact that they've hired someone else into the role, if this turned into a human rights claim, that would be kind of negative against them. Yes, that they replaced you rather than seeking they got a permanent replacement rather than a temporary replacement, so it can look bad on them. But it's normal for them to need to replace you for the time that you're off. All right, here's another one about disability at work. This one says, my boss said I was doing fine, I guess, with how the work was going. But 2 days after I asked for a medical accommodation, he put me on a PIP, a performance improvement plan. Is this considered a human rights violation or bad faith tactic? Without knowing a lot more details, it could be or it could not be. So sometimes the context is everything in these cases. So yes, whenever there are these close in time between something like a PIP or a firing somebody closely linked in time to when there's been a notification of a disability or the employer learns of a disability or something like that, obviously that does not look good for the employer, but it also is not an automatic win in your favor either. So again, we don't know really what to do. Like, we don't have enough context here. So it may or may not be considered a human rights violation or bad faith tactic. It would really depend on these things go very case by case and very detail specific. But certainly this does not look good. These are the types of cases that we take on at the firm. We mostly take on cases where people have been fired or let go when they link to a disability or sickness. Now, in this case, you're just put on a PIP. So putting someone on a performance improvement plan for reasons of punishment for taking a protected leave or as a way to start the process of firing a disabled employee, obviously that would be bad faith. But that you have to be able to prove that, and so there's not a lot you can do to prove that. Not during the process. You can often prove it during discovery examinations by getting access to records and things from the employer. Or sometimes there's even whistleblowers who will come forward and say that, yeah, that was the reason and this is what was said. But again, at this point, for someone in this situation, you would just need to do the performance improvement plan, indicate that you agree or disagree with it, but you'd have to do it in good faith and save your arguments for later on whether it was a bad faith thing or not. All right. Here's another one that says, my manager says he can't accommodate me because he needs 100% and told me to take a sick leave instead. Can an employer legally refuse light duties if I'm capable of working? This is a very complex kind of situation. So generally, no, an employer cannot say that I need you 100%. They have a duty to accommodate you. So they have to do an inquiry. If you notify them that you need accommodations, that you can't do you can work, but you would need some changes in order to make it effective, the employer has a duty to try to accommodate you and to investigate to see, is it possible that without you doing 100%, like maybe you can still do 100%, but you need certain changes to the environment or the setup or something like that. So no, like an employer can't just blankly say, we need 100%. If you can't do that, go on sick leave. They have to do a good faith investigation to determine, can they make any accommodations that would allow you to continue working? So, but you can't just say, when you say light duties, that can mean many things. It's quite possible that if light duties in the context of your job, it could be that it becomes a completely different job. And yes, if you can't do the substantial duties of your job, you should go on sick leave. The employer does not have to create a new job for you or modify your job to such an extent that it becomes not really the job that you're doing. So again, like, the employer could be correct here or the employer could be wrong. It would depend on the extent of what you were asking for accommodations. All right. Oh, we got a few comments. Let's dive back into those. This one says, my psychiatrist treating me for chronic pain said that I will be disabled from my job, which is sedentary, and work from home. I and also would be needing medical assistance indefinitely. Is this enough for CPP disability? Well, it's possibly yes. It depends on what your job was, because in theory, maybe there's another job you could do that is sedentary and work from home. Like, it would really depend. Like, if your job was really like the job you're talking about, like, let's just say, like, I'm a lawyer and I work from home, which is true. My job is sedentary and work from home. Well, I can't do that, but maybe I could do a job that wasn't as strenuous as being a lawyer and representing people and all that. So CPP disability would not just accept that just because I couldn't be a lawyer working from home, so that they would look at other sedentary jobs that maybe weren't as mentally taxing or that I could do more flexibly, because being a lawyer is not very flexible. So it may not be enough for CPP disability. It would depend on the actual duties and what your residual abilities are, and whether, if looking at your situation, trying to figure out, could you do a job from home that could pay you up to $20,000 a year? Here's a follow-up from the same person. It says, medical adjudicator to take this as an approval for CPP, and also my LTD insurer would still force me to return. Force me to return to work. Also, my psychiatrist said MDD, so major depression disorder with psychosis is severe and indefinite duration for at least 6 months. Yeah, so if you have major depression disorder with psychosis, then yes, I think that is you would not be capable of doing any work if that was still affecting you, right? And that would be the kind of things you would need details from your doctor. But the duration and at least 6 months, that would be something that CPP needs it to be indefinite. So the fact that it said at least for 6 months would lead to a CPP not approving that, because for CPP, it has to be both a severe and prolonged disability for CPP. And if it's saying at least 6 months, CPP will never approve that. They will want to wait for the 6 months. They'll say that right now it is not a permanent and indefinite disability. So you would need to wait till your doctor got to the point where they weren't saying that you're going to possibly be better or improvement in 6 months or so. Oh, that was the second part that I didn't have out there. Okay. All right, here's another question. It says here, I have an email of my accomplishments and a record of my boss saying I'm doing well. Can I use this to challenge a PIP that claims my performance has been consistently poor? Yes and no. It is. Look, it's hard to challenge PIPs. It's hard to challenge PIPs. What you want to do is look exactly at what they're saying they want you to approve. Like a whole thing about a performance improvement plan, they have to be specific about the exact performance they want improved. So generally what I would say, you're better served, like you can, if you do it in a very professional and unemotional way, say that you disagree. But again, like you're appealing to the boss and these types of things. I think the easier thing to do here would be to just do the performance improvement plan and do it well, like do the performing that they're asking. If you get into this, well, my boss said this, like, I don't know the situation on who's putting the plan in. Is it the same boss that's putting the performance improvement plan that is saying that you're doing well? Sometimes people will say you're doing well, but it's more of just they're not ready to have the conversation. So it wasn't necessarily true. I would lean towards you professionally saying that you disagree with the assessment, but you are willing to do this plan in good faith and show that you're able to do the job to the standard that they want. That's a better approach for you to take in here, because again, like these things are so fact specific that it's easier for you to prove down the road. If you ever got fired, like it's easier for you to show that you went into this performance improvement plan in good faith and did what they asked. That's easier if they then fire you or they're unreasonable about it. That's better for you than if you really fight the performance improvement plan, don't really participate in it. That doesn't usually go well for you. It's harder for you in that situation to prove that it was a bad performance plan because you're not performing well. You know what I mean? Like, so you want to be constantly showing that you are trying to do and meet the standards that they want. So that is what I would recommend. Okay, this one says I was approved under the any occupation definition a year ago. Okay, so this person's been on long-term disability probably for about 3 years, 2 years for their own occupation, and now they're 1 year into their any occupation. It says here, should I expect a major review or a medical update request on this anniversary? Yes. I would say you probably will get an annual form. I wouldn't say a major review. Most cases, you're not going to get a major review. But they generally do, especially in the first few years, they will just ask for an annual form for you to just make sure you're still alive. Has anything changed? Like, that's all it is. They're just checking in on you to make sure you're not dead and that is anything changed. to get you on record committing to certain things. So later on, maybe they can show that you said these things and it wasn't true, but they will want to get you on record with annual reviews. So yes, but it usually is not like a major thing. It's usually a form you fill out. It could be something you take to the doctor, but usually not. Usually it's just a form you fill out, like a questionnaire. Then based on that questionnaire, they could ask for more information from your doctor or things like that. It's we cover these quite a bit on here, and we're probably due to cover it again. But these forms that you fill out while on long-term disability are very important. It's important that you take them serious, and you can save yourself a lot of trouble just by filling out the forms and getting them back to them. But you do have to treat them seriously and make sure that you're accurate in the information you're putting on them. Okay. Another one. Does an any occupation approval mean I'm safe until 65? Can an insurer still force me into an IME or a paper review to try to cut me off later? Okay. So once you're approved into the any occupation period, sometimes it will say in the letter that this period runs from now until you turn age 65. Generally speaking, you are approved until 65 unless things change, or unless the insurer comes to find out that maybe you weren't honest with them or they think you weren't honest with them, then they will change their mind and try to cut you off. Now, sometimes people get approved for any occupation, but the insurer, it's more that the insurer had no choice but to approve you, but they were still investigating and didn't really come to a conclusion whether you really are fitting the any occupation or not. So they've temporarily approved it while they're still assessing. So that could be going on. But if you're not in like an active assessment by them, you're just into the any occupation, you're getting your thing once a year, most people will just be approved until age 65, unless something comes up. The insurer will periodically review your case. Sometimes they'll do investigations on social media to a certain extent to see, does what you're reporting on your annual report line up with what they're seeing on your social media? These are the kind of things. So yes, like people do hire us and come to us because they've been cut off 10 years into a disability claim. It's not common, but it does happen. And most importantly, it can be because of just not being honest. Like, so you fill out your annual report, you put on there that you don't do any work or volunteer work or anything like that, but they do a search and they see that you have recently been named as a corporate secretary on a company that's just been incorporated, right? Your brother, your husband, your son, or somebody incorporated a company and they have you on there. For many reasons people do that, but they have you on there as like a president, a secretary, these types of things. You claim you're not involved in the company at all, but these are the kind of things the insurers can pick up on. And if you didn't indicate something like that on your annual sheet, then that would absolutely be a reason they would cut you off. People get into trouble because they start working for a family business. They do volunteer work beyond just they do it too frequently. And those are the kind of things that can cause an insurance company to want to reassess the whole situation. All right, here we go. What is the most common reason people get cut off after they've already been approved for any occupation for a year or more? I would say like not responding to correspondence from the insurance company for whatever reason, or refusing to fill out forms. So if you refuse to fill out forms, that is a very common reason people get cut off. But again, it's the kind of things I'm saying, like the person puts something on a form and the insurance company through just rudimentary review and investigation finds a discrepancy. So you say no work and they see you selling things on Facebook. It's that kind of thing. Those are the cases we generally see where people get cut off. Or you say don't attend activities and all these types of things, and then they see you on Facebook, you're at all kinds of events and traveling and this kind of stuff. So it's people who have it's not congruent what you're saying on your report forms you're sending in and what they can easily observe on your Facebook and things. Now, if you're just not on Facebook or any like type of social media, like Instagram or any of these other ones that are publicly available, then they don't have much to go on. There are still public records. So like if you are added as like I said, a secretary, or when I say secretary, I don't mean you're working as a secretary. Like when you incorporate a business, there have to be these positions: secretary, treasurer, president, all that. So that's what I'm talking about. Like you are part of the founding people of a corporation because you have one of these necessary positions. That's the kind of thing, when they see that kind of stuff, is where you can get into trouble. All right, need a little drink here. My God, we barely put a dent into these questions. If anyone's in the chat, just let me know if I haven't hit your questions yet, and I will do my best. There are, like I said, there were so many. I couldn't get them all programmed in here before I went live. Let's go on to this next one here. So this one says, I'm on a job protected leave of care for a relative, and my boss just threatened to hire a permanent replacement. Is this a legal grounds for a human rights or reprisal claim? Yes, it is. So basically, again, the wording here needs to be, they're threatening a permanent replacement. Well, they haven't terminated you. So I guess a permanent replacement would seem to mean that they're going to terminate your job. But until you're terminated, like, you can be on a leave. So sometimes you have to just let this play out. You can't jump the gun on it. You have to wait until they send you a termination letter, or when you want to, when you go to return, then when you go to return and they say there's no job. Now, you have to check, just because like these protected leaves are not indefinite. They are time limited, especially for things like caring for a relative. So if you're extending beyond the statutory time, then you can be terminated. They don't have to keep you. You don't have to hold your job open if you say, oh, I need a 1-year leave to care for this relative. Like, each province sets out what are the amounts of leave that you're allowed to take. So that's something else you have to consider. Okay. This one says, if my employer is pressuring me to quit while I'm on caregiving leave, should I resign to avoid the drama, or does that mean I lose my rights to severance and EI? Yes. If you resign, you would lose your rights to severance and EI, most likely, especially if they're pressuring you to quit. So there is this thing called constructive dismissal, and we get many, many people calling us wanting to do a constructive dismissal case. That's the situation where your employer hasn't fired you, but it's so uncomfortable and unpleasant being in the workplace or the situation that you want to say that what their actions are amounting to the same thing as them firing you, so you can resign and still get severance pay. If you're going to ever do that, really get legal advice. Do not trust ChatGPT or any online AI. They constantly get this stuff wrong, because I do work with it every day. You really should get advice on whether your situation would qualify as a constructive dismissal or not. But generally speaking, no, you do not want to resign. What you would need to figure out is the amount of caregiving leave I'm taking reasonable? And would I have, like, maybe they do have grounds to let you go if the caregiving leave turns out to be too long. So you'd have to go by your province and figure out what's the protected leave that you have. Types of protective leave can be like caregiver leave, maternity leave, sick leave, and these types of things. Depending on the type of leave, the employer may have an obligation to allow you to go longer. Like I said, there are minimums in each of the provinces, but this is something that you would need to have it looked at on a case-by-case basis. Okay. Now, the way this, so there is an interplay of protected leaves. There is a layered, you have to think about this in a way that there are protected leaves, and then there is duty to accommodate, a protected human right. So sometimes, like in the case of sickness, that is a protected leave, but it falls under human rights. So if something falls under human rights, then the employer has a duty to accommodate you to the point of undue hardship, and that can include allowing you to take a longer leave, right? So it really depends on the type of protected leave and whether it falls under human rights. Things that fall under human rights, you would have a ability to have that protected. Now, things like caregiver leave that may sometimes fall under a protected ground under human rights called family status. I have to take a look at that, look at the particulars of your situation, but that's possible that it could, if it was deemed to fall under the protected ground of family status, then the employer would have more of an obligation to allow you to take the leave to the point of undue hardship for them. But again, you'd have to have your situation looked at to see whether it would qualify under human rights or if it just is a type of protected leave, because the two are layered. All right. Can an employer legally replace me while I'm on family medical leave just because they need the help? Or are they required to hold my exact position? I've kind of answered this. So it will depend on the length of the leave and whether this type of leave would fall under the Human Rights Act of your province or the federal human rights if you work in the federal jurisdiction. They're never required to hold your exact position. They have a duty to accommodate you. Generally, that will be your exact position. And again, if they move you from your exact position, they do run the risk that could constitute a termination, a constructive dismissal. But there is flexibility there. This is not your disability. This is a situation where it's caregiving for a family medical. So that's something you'd have to look at in your province to figure out, is this going to be a protected leave in your province? All right, let me see here. Okay, my doctor, let's see here. My doctor, we got to hold on. Before we get into that one, let's go look at the questions here. Let's see here. Still waiting to return to work. Supervisor, Canada Post. Duty to accommodate question was sent to Jen. Okay. Let me go see if I can find it here. You might have been one of the ones near the end. Let me see. I might have answered it earlier. Have you been here the whole time? I answered a bunch of questions at the beginning about, let's see here. Canada Post. Still, you've been here the whole time. Okay. Where's that question? Oh, I think I see it right here. Yeah, I just haven't got to it. I think it's this question here. So let me, you let me know if this is it. I'm a 25-year employee of the provincial government. Oh, no, that's not it. Hmm. Yeah, I'm not seeing it. I'm looking at the stuff that Jen has posted here. So, okay, maybe it's this one here. Still waiting. Return to work. Supervisor. Duty to accommodate. Let me see here. Okay, I think it's this one here. After being on disability with traumatic brain injury since 2005, does my employer have to accommodate my return to work if cleared by my medical doctor with restrictions and gradual return to work? Turning 65 in August 2025, so CPPD and LTD will stop payments. Will receive Canada pension, CPP, and old age. Is that the question? Is that the one? I wonder. Don't think I covered that one yet. Yeah, okay. So that is it. Let me look at this one again. So let me I'm going to try to let me see if I can post it so everybody can see it here. It might be too much wording. Yeah. Okay. So here it is here. So after being on disability, let me go read the full thing again. So the full question is, after being on disability with a TBI, actually, let me see if I can shorten this up so we can fit the whole thing in here. Since 2005, okay, and then you wanted to know about turning 65 soon, and there we go. Okay. Let's try this again. So it seems like what you're asking is when my LTD runs out and CPP disability runs out, can I try a return to work with my employer? Like that does seem what it seems like what you're saying here. And it would be difficult, I think, like because it would raise the question, like, why aren't you trying to return to work now? You've been on disability since 2005. So I think your employer would have a very strong argument that this employment has been frustrated. Um, and so I think you would have a hard job to prove that because it just seems like something too convenient that now that the disability is stopping, now you want to come back to work. Like it would not be consistent. Like if you waited right until everything stops to do this, I just don't see you being successful at it because they would say this doesn't make any sense. Like if you wanted to try to return to work, why not return earlier? They would say it's too convenient that now since your disability is stopped, that now you're all of a sudden going to go back to work. I think that's where the problem would be. I think that's where you'd run into the problem there. So it's unlikely they would have to accommodate you. Like, I don't know, but if you have not been approved to go back to work, like right now, you'd be getting CPP disability. That would be being paid on the basis that you're incapable of doing basically any type of work. So your employer would have very strong evidence to say that there's no way that this person could be accommodated to come back to work. And if so, like, why wouldn't they have tried, like, 2005 is 20 years ago, right? So is that right? 20 years? Yeah. Well, 20, 21 years, I guess. But that's the kind of arguments you'd run into. So I don't think it would be realistic to try to get your employer to accommodate you. But I don't know if the medical evidence showed that you had made a recovery and there was some reason that it was now. Just because you're 65 is not a reason that they couldn't, in theory, bring you back. But I think the employer would balk at that and would argue that you are the employment has been frustrated. In fact, like, they would have very strong evidence that the employment was frustrated, because frustration of contract is something that factually happens at a certain point in time. So there would have been a point in time where, say, even back in like 2010 or any time there, where there would be a lot of medical evidence in your LTD claim file and in your CPP claim file that would confirm that you're incapable of any type of employment. So at that moment, when that medical existed, especially for the CPP disability, that would have been a point where your employment would have been frustrated, and your employer, the employer can claim that it was frustrated back then, and that they've just let you stay on for benefits reasons, maybe through the union or different types of things. Now, again, let me rephrase this. Since you probably are in a union, so maybe that the rules of your collective agreement would dictate the whole situation. Yeah, let me back up there, because I think you did mention Canada Post. So if you are in a union, then the regular rules that I'm talking about of frustration of contract and these things would not necessarily apply. There is a similar principle that applies in the context of collective agreements. It's not called frustration of contract. It's called innocent absenteeism. So maybe that would apply in your situation. But all in all, you would need to go through your union to try to get back to work. And I would anticipate a difficult road ahead if you wanted to try to do that. All right. And just let me know if you have any follow-up questions on that. So just back to the person who was saying they're on the family medical leave. Many provinces do have family status. I'm just thinking in the back of my mind as we're talking here, like, many provinces do have family status as a ground of discrimination. So you would need to look at whether taking a family leave like that would be considered family status. And if it is in your province, then your employer would have to accommodate you to the point of undue hardship. And that could include allowing you a more extended leave than would normally be allowed under one of these protected leaves. Because the protected leaves have a certain minimum time period under the Employment Standards Act of each province. But if the type of protected leave also falls under the human rights, that's where you get into they have to basically hold your employment to allow a more extended time. But it's not something you would want to quit over. Definitely not. You would want to challenge it. And again, if it was a human rights discrimination, then you have to bring the human rights complaint within 1 year of the date of when the last time they did the discrimination. So it is something you don't want to sit on forever, because you do have a time period in which to bring a human rights complaint. All right. I'm trying to think of which ones Okay, here, where are we at? Okay, here we go. My doctor cleared me for a gradual return to work with restrictions. Is my employer legally required to accept these conditions and find me a suitable role? No. Not necessarily, right? It's not necessarily, it's not dictated by it would determine the quality of the information your doctor provided, the type of work you had, the kind of restrictions they were talking about. It may just be completely unreasonable on its face that they could ever accommodate those types of conditions. So that would be something you have to look at. So It's a first step if your doctor is doing that, and generally, yes, it would put the employer a duty for them to inquire and to do an investigation to determine can they accommodate, but it's not guaranteed that once they do that inquiry, the result might be that what the doctor's asking for is not specific enough, it goes too far. So just having those recommendations from a doctor in and of itself will not require the employer to take you back and find you a suitable role. The duty to accommodate does not mean they have to create new work for you or find a new role for you. The duty to accommodate generally means that they have to accommodate you into the job that you had with reasonable accommodations, short of undue hardship. They don't have to create other work or find other jobs for you in the company. So they can offer you other ones, but this is something that gets argued over, and it's very case by case on what constitutes a new job versus something very similar. So it's not a black and white situation. Oh, okay. So here's the question. I did have this person's one queued up. This was the one that the person just asked about. I had it written as, if I turn 65 in August, if I attempt to return to work now and it fails, will it mess up my LTDs right before they are set to end? I mean, yeah, they definitely could mess up your LTD and CPP right before they're to end. With CPP, you could, it's so close though. Like, I just think if you try to return to work, you wouldn't you wouldn't be able to go back to your old employer. I just don't see that a world where that would ever that would ever work out. But I'm willing to be proven wrong, because I think this person said they were off since 2005. So, but in theory, it could mess up things near the end here, yes. But ultimately, with CPP, you could go on a vocational rehab program, but again, like, we're talking 4 or 5 months. So it's hard for me to give you a definitive answer on this one, but ultimately, like, I am a supporter of people who want to try to do return to works. So if you have a doctor that says you're ready to return to work and attempt one, then I would support you in saying that's something you should try to do. You just would have to be very upfront with your insurer and the CPP about it. And the fact that you're close to age 65 and when the end of your policy would be something that the insurer and the CPP would need to take into account. But it's such a short period of time until then. I don't know how they would handle it, honestly. They would probably just not want to deal with it because you're so close to the end. They're not going to care. There's likely they just wouldn't care, but you would need to confirm with them what you're doing to try to work, report the income, and that kind of thing. Okay, so this person just here, they put a post to the question. Says here, I thought a federal government department had to accommodate my return before age 65. No, not my understanding. But again, I'm not giving you direct legal advice, but the duty to accommodate is short of undue hardship. And again, if you're in a union, then all bets are off. I can't really give advice if you're in a union, because whether they have to accommodate you or bring you back would depend on what your collective agreement says. But it's not necessary that they have to accommodate you, because the fact that you've been off work so long on disability, you would be most likely deemed incapable of accommodating you. Or if you could have been accommodated, like, they would have wondered, well, why wasn't it done sooner? You'd have to show that there's been some real change in your medical condition that's happened recently, something that happened recently. And you'd have to go through your union and things like that. Generally with the federal government, this doesn't come up because they force you into medical retirement. So if you were at Canada Post, that is technically not a federal government department. So the rules are a little different at Canada Post than they would be if you were in the actual federal government. Canada Post is it's not the same as the federal government. They have different unions. It's really it's slightly different than working directly in the federal government. But I do think it's unionized, so you'd have to go through your union for a situation like this. Okay. All right. So this one says, I'm a 25-year government employee on LTD. If I take a 40K severance, will Canada Life just stop paying my monthly payments until 40K is used up due to the offset rules? Okay. So this is a tricky one. So again, potentially, yes. If the policy allowed for offsets, then if the policy allows for offsets of severance, then yes, they would offset it. It depends on the wording of it, but they would reduce the 40K into what are the weekly or monthly payments that represents, and then the insurer would offset those for the same period. So 40K of severance would equal, say, 4 months. Then the LTD would be able to offset for 4 months. It's not necessarily just dollar for dollar. It's like time period for time period, which can work out in your favor. Because the LTD can only offset the total amount of what the LTD would pay you. Usually you're paid more than what the total LTD is. So even when the LTD offsets the severance, it's not going to take all of it necessarily, right? Because if you get paid bi-weekly, or if you get paid monthly, say, you would look at what's your monthly LTD payment and what's your monthly payment from work. Now, sometimes it does equal out that it's a total offset, because the 40K out of that is going to come, they're going to subtract like taxes and that kind of stuff. So once you take that off, sometimes it does equal very close to what the LTD is. Okay, another question. If I accept a medical layoff with severance, do I lose my health benefits and ability to continue contributing to my provincial pension plan while on disability? Yes, you do. If you do a severance, you are ending your employment. So you do not keep any employment benefits or an ability to continue to be enrolled in the pension. So yeah, with severance, again, I need to know your exact situation and what they're offering. But generally, if you are severing your employment, that means it's ending and all employment benefits would end. You'd have to, normally what happens is you would need to convert these over into an individual plan, which is usually not as good, or you'd have to go find some other benefits, which can be very hard to do. It's one of the reasons people don't want to do severance, is because the health benefits can be worth more than anything else. It says here, can Canada Life force me to take early CPP retirement at age 60 to reduce their costs? Are they only allowed to make me apply for CPP disability? I can't say. It depends on your policy, and there are some weird policies, especially there's a good chance this person's a federal government person. So there are these bridging things that I haven't looked at in a while. What they can and cannot do would be in your policy. So if it says in the policy they can force you to take early CPP retirement or face a reduction in LTD, then that is something they can do. But it has to be written in the policy. My doctor has cleared me to return, but the workplace is hostile and toxic. Am I legally required to go back to that environment, or is it my employer obligation to change it first? Okay, this is a very good question. We get this all the time. So this is very difficult to answer, because what is considered a hostile and toxic work environment can be very subjective. So what one person feels is hostile and toxic may not legally be deemed to be so, right? And so if this was a legally deemed hostile and toxic work environment, then you may not be required to return. The problem with this is that is a very difficult thing to try to figure out. And so I'm very quite often I will rarely tell people, unless I've been able to do a very good review of their case, that that is a route to go. Generally, you have to go back, notify them that it is still hostile and toxic, and have them you have to give the employer opportunity to fix the issue. So that means reporting it, having them, once you report it, they have a duty to do an investigation and these types of things. But it's just a very, very difficult thing. Um, and something that I can't give off the cuff advice. It has to be very specific to a situation, and it's generally difficult to prove that it is such a toxic environment and that you've given the employer the opportunity to fix it. That is often hard to prove. So generally, you have to have things in writing that here is objectively what happened. Here's the things in writing, and get a lawyer to review it and see, are these things that you're talking about, do they constitute a hostile and toxic work environment legally? Because it can be very uncomfortable and terrible work environment, but doesn't hit these legal thresholds. So this is probably the same person. And again, it's the same thing, that it's so subjective that can't answer this question. If a workplace is so poisonous that it's impossible for me to return without getting sick again, can I claim a constructive dismissal and leave with a severance package? Maybe, but it is, again, very hard. This is what people want to do. They just don't want to have to deal with it. They just want a severance to be gone, and I completely understand that, but it is very difficult to prove. And so, in theory, it is possible in some situations that you could, but again, it would have to be one that it would be legally meet the conditions, that it is a poisonous work environment, that it's impossible for you to return. Again, these are all very subjective things that not everyone's going to agree on, even if you feel that way. So legally, it is hard to prove these things without you going through all the steps of putting in complaints, having there being investigations, and that kind of thing. So generally, the answer to this is it is possible, but you would need to get very good legal advice on this, because you have to know whether this situation, if there's proof of enough proof, enough evidence that you've given the employer a reasonable grounds and time to fix it. But in theory, yes, you can claim constructive dismissal in these kinds of situations if you can prove that it is a legally toxic environment and that the employer has not taken reasonable steps when notified of this to do the investigations and all that kind of stuff. All right, here's another one. Can I ask an accommodation to be moved to a different manager or department if the current environment is the reason I went on medical leave in the first place? Generally, no, that is not the type of accommodation that is typically going to be allowed. You, as an employee, you can't dictate who your bosses will be or where you work. The employer has to do an investigation and has an obligation to provide a safe, reasonably safe workplace. So, but no, those aren't the types of accommodations that you can ask for. You would have to deal with that by having the employer do an investigation to determine if the manager is acting inappropriately to the level that would be deemed to be like a toxic or that type of work environment. It's very hard to prove that. It might well just be that it's proved that you and that manager do not get along, and that is not the employer's issue. So they would put it in a situation where they would either fire you or you would quit. If they fire you, they have to pay you severance, unless this is unless you're you're in a union or something, then it would be whatever the process is under your union agreement. All right. I'm running out of steam here, so I have a few left. We may have to leave some of these until next week. I think I've got 3 or 4 more that I didn't get logged in here, so I might have to leave those for next week. So let's finish off these ones we have here. This one says, my stroke happened after I was fired, but while I was on EI. Can I still apply for LTD through my old employer? Or did my coverage vanish the day I was let go? Okay. So that is a good question. Sometimes if you were fired and if the stroke happened while you were still in the period in which you were receiving severance pay, then you might be able to file your LTD claim. So the LTD did not necessarily vanish the day you were let go, but it depends on what you signed. Like if you signed documents and agreements, then it's possible it did vanish the day you were let go. So it really depends on what you signed when you left, how the severance was worded. But in theory, no, like it doesn't necessarily mean the day you're let go that you would lose your coverage. Often the coverage will continue for at least your LTD coverage would continue for at least the notice period. So whatever the notice period was, so there's generally a notice period that is through the Employment Standards Act, and sometimes they pay beyond that. So that is something you would need to investigate on when your stroke happened. Did it happen during the notice period for which you were being paid? And it also would depend on what you signed when you left. This one says, my CAT scan was clear, but I have a major cognitive issues and headaches that stop me from working. How do I prove severe disability to Service Canada without hard imaging evidence? First of all, hard imaging evidence is never something that's needed for proving disability. It's almost impossible because even imaging evidence that shows something in your brain, that doesn't mean you're disabled, right? So disability is a functional thing. You need to show that regardless of, like, there is nothing on a CT scan that's normal. Most things don't show up on a CT scan. You would need to have evidence of your headaches, and that would come through you constantly going to the doctor about them, trying different medications, and that's how you would prove it. So you don't need imaging. Imaging is never something that is a smoking gun to have these cases approved. This one says, since my EI sickness benefits have run out and I'm still unemployed, what is the fastest way to get income support? CPP disability or an LTD claim against my former insurer? So neither of these are fast. And certainly an LTD claim against the former insurer is going to be with a lot of problems, because even theoretically, if you did still have coverage, they may fight that. So I don't think either of these are going to be faster. Probably CPP disability would be faster in my mind, but CPP is not something that's ever, so none of them are fast. But if it's comparative, I would look into both of them but get the process going on CPP disability if you feel like your doctor is going to support you and that you can't go back to any type of employment. There, that is it. Now, if anyone is here that I didn't get to your question, there are a couple left. So if someone's here specifically and you say, look, you didn't get to my question, then I will go try to find it and do it. But otherwise, I'm going to save them for next week just because I'm too burned out. All this talking for 2 hours. Well, I guess we've been about an hour and a bit, but all right, folks. So if there's no more questions, I will leave it for there. I believe I'm back next week. Let me check my calendar here. And I'll talk to Jen to make sure we don't get crossed up on our information. Let me go check my calendar right now. Okay, let's have a look here. Week. Yeah, I'm here next week. Looks like I'm here for the next 2 weeks. Yeah, then it's okay. Yeah. Oh, wait a minute. I'm in the wrong month here. Oh my God. Okay. Yeah, so I'll be here for the next couple weeks. It looks like it's the week of, yeah, it's later in April where I'm going to be gone. So we'll get that figured out. Yeah, I'll be gone a couple weeks in the middle of April. Yeah, so we'll just stay in touch. It was great talking with all you guys. Please just send in your questions. It is helpful for people to send in questions like this, and they just got backed up because I've been gone for a couple weeks. But send your questions in. you can send them to support@resolutelegal.ca. And I'll put that in the comments here just so people see it. You can send them to there, or you can just submit them through the website, and we can answer them on here. Just get them to, you can phone in and say, I have a question for there's many ways. You can phone in, you can send a chat through the website, you can email it in. There's a bunch of different ways to get it in. What they do is they just, the intake team just puts them in we have like a chat area where we put them all, and then I know to see them when we get on here. Okay, that's all for now. I'm going to call it a night, and I will see you guys next week. Bye-bye.